My lord, by corroboration, I meant corroboration which implicate the accused in the commission of the offense. And there was nothing, absolutely nothing in the evidence of Zungu that implicate the accused in the commission of the offense. In fact, what Zungu testified about, he referred to not less than 5 people that he met on that day. Not people he met on that day. He referred to not less than 5 people in his evidence. And such people were not called as witnesses in this case. And on the transcribed record of the 7th of September 2023, on page 29, line 10 to 14, this is what the court said about such tendency of this witness Zungu to refer to hearsay evidence. And I quote, by court, just to place it on record that I will not entertain the hearsay, I'm not going to take it into consideration. Mr. Baloyi, as the court pleases, by court, all the hearsay, Mr. Baloyi, as the court pleases. So, the bulk of the evidence of Zungu refers to hearsay evidence in the sense that no witnesses were called before this court, despite him referring to those people who were called before this court to corroborate the evidence of Zungu. The other issue, my lord, that I wish to address is the concerns which were raised by court that at some point, accused number 2, Bongani Ntanzi, met Jack Telezi. That is after the court appearance of Mr. Ntanzi, accused number 2, before this court. He refers to, this is what Buthelezi says upon that meeting that transpired. He says, Bongani Ntanzi said there was a party, and that he said he was in the company of his friends. He said it was Mapisa and them when he referred to his friends. By Mapisa, it was never pursued through the evidence in chief to this witness by the state, my lord, to clarify to the witness which Mapisa was he referring to when he testified with reference to Mapisa that Mr. Ntanzi, accused number 2, had said he was with Mapisa at a certain party with his friends in Fosloras.
Again, I want to reiterate how brilliant Nxumalo is, okay? They went on break. Before they went on break, the judge threw some spanners, okay, into Nxumalo's presentation. And this was, what about Jack Buthelezi? You're saying there's no evidence that corroborates Zungu. What about Jack Buthelezi? And what about, spoke about Jack Buthelezi, and then he spoke about Mzansi, saying he went to buy Irish liquor and came back and was celebrating the unaliving of SENZO MEYIWA. But Nxumalo comes back from break, which was not a long one, by the way. I want to emphasize that. And he is ready, one, to quote Jack Buthelezi and what he actually said. And then he reiterates that the state never verified who Jack Buthelezi was referring to when he said Mapisa. He didn't say this one, yeah, accused number 4, Umthokoziseni Mapisa. He just said Mapisa. Therefore, that doesn't mean if you are a Mapisa, then you are the Mapisa in the SENZO MEYIWA trial. That is not the case. How do we know? Let's look at the Kwabeni Zungu situation. They are all Zungus, right? Just because they are Zungu doesn't mean it's Kumbuzo Sizwe Zungu. And again, Nxumalo points out that the state did not call anybody else who was at that party to validate Kumbuzo Zungu's statement. Why? Because he's a constable, and therefore what he says must be taken as fact. As we know, my lord takes everything that Sizwe Kumbuzo Zungu says as fact. But we are not there. Let's continue listening on to Advocate Nxumalo's brilliance, in my opinion, that is. That's far. Okay, I'm yet to be proven otherwise. His brilliance in his application for the section 174 for accused number 4. Don't forget, not paid. Let's continue listening on.
Zungu could not explain what occasion on page 47, 48 of Exhibit C, despite claiming that he was with accused number 3 and 4. In his evidence in chief, he testified the person wearing a cap was accused number 2, but when confronted that the person wearing a cap was in fact accused number 4, Mr. Mapisa, he retracted his earlier version and said he could not see accused number 4 on the picture. The common purpose doctrine. Instead versus Mawala unreported case number AR267 of 2016, delivered on the 12th of October 2018, Pile J at paragraph 19 said the following regarding the doctrine of common purpose. The court held that common purpose is a legal construct to assist the state in prosecution where evidence is insufficient to link offenders to one another and to the crime. It is evident that the principle of common purpose is not just a tool, but an effective mechanism created to serve justice. Without it, the state will have been clueless as to the true identity of the one who committed the act. The common purpose principle makes it easier to not just punish the true actor, but also to his co-conspirators who had the intention to commit such crimes that caused the unlawful results. Close quotation. Instead, Versailles Mketezi, 1989, Volume 1, SA 687, capital letter A in bracket at 705 I to 706 C, the court established that a person to be held liable for a crime committed under the doctrine of common purpose, where there is no evidence of prior agreement, the following criteria must be met. A, presence at the scene. The accused must have been present at the scene of the crime where the violence was being committed. B, awareness of the attack. The accused must have been aware that the criminal attack was taking place. C, intention to make common cause. The accused must have intended to make common cause with the other participants or other co-conspirators committing the assault. D, active association with the attack. The accused must have manifested his sharing of a common purpose by himself, performing some acts of association with the conduct of the others. E, intention to kill the deceased or to contribute to his death. The accused must have had intention to kill the deceased or contribute to his death. In the light of the facts of this case, it is important to note that the common purpose doctrine, as exposed in State versus Mketezi and others, has been pronounced by the Constitutional Court to be constitutional. In State versus Tebas, the most critical requirement of active association is to keep too much a liability. Current jurisprudence premise on a proper application of State versus Mketezi and others makes it clear that 1, there must be a close proximity, in fact, between the conduct considered to be active association and the result. Roman figure 2, such active association must be significant and not limited participation removed from the actual execution of the crime. Zungu's evidence, which I submit, that is version and that of accused number 4, are mutually destructive. Zungu met accused 4 at the hostel. Gwabeni introduced the accused to Zungu, despite Zungu knowing the accused. Zungu later met accused 4 after accused 1, 2, and 3 had entered Gwabeni's room. Accused 5 entered the room, followed by accused number 4. This is according to Zungu. After some time, he was going to his vehicle. He noticed that the vehicle keys were not with him. He went back and asked Gwabeni, where are the vehicle keys? And Gwabeni made a call to a person whom he thought was related to accused number 4. And he made a call to a person whom he referred as Mzansi. And he thought that person was accused 5. Did not answer the call. Zungu testified that accused 4 arrived and gave him the vehicle keys. According to Zungu, accused 4 showed his greatest fullness and clapped his hands together. Zungu's evidence, it must be noted, my lord, that it does not detail a plan by the accused to execute the assassination of the deceased. It does not place the accused together or even himself, Zungu, that he overheard such a plan. Zungu's evidence does not reveal any prior agreement amongst the accused, including accused number 4, to kill the deceased. In the absence of a prior agreement to kill the deceased, it therefore becomes important to apply the 5 principles as stated in Mketezi's decision. The presence at the scene. The accused must have been present at the scene of the crime where the violence was committed. There is absolutely no evidence, my lord, that accused number 4 was present at the scene of crime where the violence was being perpetrated, either circumstantial or direct, at or near the scene of crime at house number 135. My lord?
What about the confessions?
I'm still coming to confessions, my lord.
I see.
Yes.
Okay.
Oh my goodness, this moment was hilarious because you can tell that Nxumalo, okay, uzithulele, uzwide kalanga, cannot believe that he literally got away with that. He literally pauses and waits for my Lord to come for him, but my Lord has no comeback. Oh my goodness. This is the moment where my Lord asks, well, what about the confessions? What about the confessions? And Nxumalo says, we are not there, okay? We are not there. I'm coming to the confessions right now. I'm just trying to show you that there is no common purpose. And most importantly, accused number 4 was not at the crime scene. And Zungu fails to prove this. He fails. He might be the state witness of note, but he fails to put accused number 4 in close proximity of the crime scene, and he fails to meet all the other criteria of common purpose as outlined in the Ngetezi decision, okay? So, my Lord, you can't ignore Ngetezi decision is actually a decision, okay? You can't just pretend you don't know it. So, again, I emphasize, I love that this time he came through with previous court citations, and these are enough to stop my Lord cold in his tracks. It's no longer Ginenda going on and on and on and on and on. It's no longer witnesses going on and on and on and giving wrong information, misleading the court. It is now citations. And when it comes to citations, those are case laws. They cannot be undone. So well done, Nxumalo. I'm impressed. You deserve to smile your way through this. And you are handling my Lord well, okay? You are now in gear 6. Keep going. Let's get into the next part.
B,
That's amusing.
the issue of confessions, my Lord.
And I'm not thinking what you're thinking.
No, I'm absolutely on different terrains.
Yeah, I can tell you what I'm thinking, not what you think I'm thinking.
All right, thank you.
Section 218
218.
and 217. What do they say?
217 is admissibility of a confession.
217 is about pointing out.
218 is pointing out.
Okay, fine. And then 217 is?
Admissibility of a confession.
Yeah, fine. What does it say?
I'll have to get.
You have the app there so that we all educate ourselves.
In fact, 219 is, I think, for the purposes.
219 is no problem with 219. Yeah, let's read it.
I told you Nxumalo is cruising well, okay? Cruise control has been activated. That's why he takes a moment to laugh, okay? Because the confidence, and he's like, what? I've made it this far in my presentation? Man, I must be doing real good for the judge not to interject. This is shocking. And then finally the judge says, what are you laughing at? What are you laughing at? And then the judge says, I know how I'm going to get him. And then he starts saying section 218, 217, dun dun, and he thinks he's going to confuse Advocate Nxumalo's Tulele, and he's right there with my Lord to say, nope. My Lord says section 217 is pointing out. Nxumalo says, no, that is section 218. Like, that was just so nice to listen to how confident he is. He's come a long way. He has come a long way. One thing we can say is that he has grown within the SENZO MEYIWA trial with his confidence. Let's listen to the reading of the word, okay? Funda Temba Funda. Here goes Baloy.
217 is quite lengthy.
Yeah, quite, yeah.
Yeah. Well, must I
Yeah.
record the whole of it? If it carries my land friend's blessing, section 217 reads as follows. Admissibility of confession by accused. Subsection 217(1). Evidence of any confession made by any person in relation to the commission of any offense shall, if such confession is proved to have been made freely and voluntarily by such person in his sound and sober senses and without having been unduly influenced thereto, be admissible in evidence against such person at criminal proceedings relating to such offense, provided, paragraph A, that a confession made to a peace officer.
Just bring that thing here. It's not what I want us to read. You know what I want you to read?
No, I'm not thinking what you're thinking.
Yeah.
Perhaps they could have in mind the confession made to a magistrate, that is prima facie.
Yeah. Yeah, just listen. Here it is. It's admissibility of facts discovered by means of inadmissible confession. It's section 218, subsection 1.
Yes.
You know it.
Yes.
Evidence may be admitted at criminal proceedings of any fact otherwise in evidence, notwithstanding that the witness who gives evidence of such fact discovered such fact or obtained knowledge of such fact only in consequence of information given by an accused appearing at such proceedings in any confession or statement which by law is not admissible in evidence against such accused at such proceedings, and notwithstanding that the fact was discovered or came to the knowledge of such witness against the wish or will of such accused.
I'm still trying to understand the...
Okay, you remember Ginanda?
Yes.
Ginanda, you kept on asking him, how does he know that accused number 1 is involved? How does he know that accused number 2 is involved, etc., etc.?
Yes.
And Ginanda said, as the investigating officer, after accused number 1 allegedly made a confession to Maboto, I went to fetch the confession the following day, and I read it. Remember?
Yes, I remember that.
The same thing he says about accused number 2, I think. Rapadi, after Rapadi had made the confession,
Yes.
written the confession,
Yes.
this guy repeats to say he went to fetch it and read it.
And read it, yes.
The same thing with the magistrate Konje. After he gave the confession to Mrs. Kruger, the senior,
He did the very same
he
process.
did the same thing. So in
Yes.
other words, if you read this, you'll get what is meant by this. So he acquires that knowledge, Kininda, by the fact that he read the confessions. And that evidence, according to this section, is admissible to him. But it is not as admissible as against a co-accused.
Yes.
Fine, you've heard me now. What do you think, Mr. Baloy? Is it witchcraft?
Yes, in fact, we question the case of Korashi, I think, that deals precisely with that.
Okay, fine. Let's go ahead.
B. Awareness of the attack. The accused must have been aware of the criminal attack was taking place. There is no evidence that accused 4 was aware that the criminal attack was taking place.
Okay.
C. Intention to make common cause. The accused must have intended to make common cause with the other participants or those committing the assault. There is no evidence that accused 4 intended to make common cause with those committing the assault. D. Active association with the attack. The accused must have manifested his sharing of a common purpose by himself performing some act of association with the conduct of others. There is no evidence that accused 4 manifested his sharing of a common purpose by himself performing some acts of association with the conduct of others. E. Intention to kill the deceased or to contribute to his death. The accused must have had intention to kill the deceased or contribute to his death. There is no evidence that accused 4 had intention to kill the deceased or to contribute to his death.
One thing about my Lord, he will work overtime, extra hard. Read section 218 and done just for the confessions to shine bright like a diamond. No matter how much the confessions are said to not have been obtained freely and fairly, not with this, my Lord. My Lord is certain and determined that those confessions will never leave any association with the accused. So let me know your thoughts in the comment section down below. Did you get what my Lord was implying about the confessions? Basically, he said, whatever you say, don't even try it, okay? Those confessions are admissible, and the confessions by accused number 1 and 2 were read by Brigadier Nicholas Gininda, and he's a brilliant investigator, okay? He's a brigadier. So he read them and then he understood the confessions, and then that is how accused number 4 is implicated in this crime. So stop saying there is no evidence against accused number 4. So the Nxumalo continues on, and he goes on to continue down his list to say, no, there is no evidence. Putting accused number 4 at the crime scene, putting accused number 4 that he planned this unaliving of SENZO MEYIWA, or that he contributed in any way. In fact, Zandi doesn't even mention him, okay? With that, let's get to the next video. Let me know your thoughts in the comment section down below. Thanks for watching. Bye.